My divorce lawyer filed a motion to withdraw in Chicago, Illinois. Now what? Yet even this professional relationship can be ended if your divorce lawyer decides to file a motion to withdraw from your case. Because the rules that govern attorneys in Illinois require them to step away under certain circumstances, it is important to understand the legal standards and your obligations once a motion has been filed. Illinois lawyers are bound by the rules of professional conduct. Rule 1.16a makes withdrawal mandatory when continued representation would violate the rules or the law, when a lawyer's physical or mental condition impairs the ability to represent the client, or when the client discharges the attorney. These situations protect clients from being represented by someone who cannot ethically or competently advance their case. Rule 1.16b allows a lawyer to leave a case if withdrawal can be accomplished without a material adverse effect on the client's interests, if the client insists on criminal or fraudulent conduct, or uses the lawyer's services to perpetrate a crime. Withdrawal is permitted if the client demands action that the lawyer finds repugnant, fails to fulfill obligations to the attorney after warning, imposes an unreasonable financial burden, or makes representation unreasonably difficult, or if other good cause exists. In practical terms, this means that a law firm may withdraw for any reason so long as the client's interests are not harmed and proper procedure is followed. A client in Chicago can often find another attorney in the city, and non-payment of fees is a common reason for withdrawal. An attorney cannot simply announce that they are no longer representing you. Illinois Supreme Court Rule 13(c) requires a written motion for leave to withdraw that states the client's last known address and must be served on the client, opposing counsel and other interested parties. The court must approve the motion, and it may be denied if granting it would delay the trial or otherwise be inequitable. Judges have an interest in keeping their dockets moving, and they often consider whether a trial date is approaching before allowing an attorney to withdraw. Because ethical reasons for withdrawal usually cannot be disclosed without violating attorney-client privilege, clients who object to an attorney's ethical justification may have to waive privilege and discuss sensitive issues with the court. If you do not want your lawyer to withdraw, you must appear at the scheduled hearing and explain to the judge why the attorney should continue to represent you. In the author's experience, motions to withdraw are usually denied only when a trial is imminent. Should the court deny the motion, you remain under contract with your lawyer and will owe fees for past and ongoing work. However, keeping an attorney who does not want to work on your case is rarely advisable. While lawyers have an ethical duty to zealously advocate for their clients, human nature may undermine that zeal when the relationship has soured. Once the court grants the motion, Rule 1.16d requires the departing lawyer to protect the client's interests by giving reasonable notice, allowing time for new counsel to be hired, surrendering papers and property to which the client is entitled, and refunding any unearned retainer or advance fees. The attorney typically submits a proposed order that gives the client 21 days to retain new counsel or file a supplementary appearance. If you agree to proceed with a scheduled hearing without requesting a continuance, you may inadvertently waive the right to the full 21 days. Illinois case law presumes that litigants, even when represented, have a duty to follow the progress of their case, so courts are reluctant to grant extensions beyond this transition period. After withdrawal, you must act quickly. Illinois Supreme Court Rule 13(c)(2) requires that, unless another attorney is substituted at the time of withdrawal, the party must file a supplementary appearance within 21 days stating an address for service of notices and documents. Otherwise, opposing counsel may send notices to the last known address on file. During this 21-day transition period, nothing prejudicing the client's rights should occur. Appearing in court without having filed an appearance may result in being unable to speak or present evidence. Filing your own appearance without a lawyer makes you a pro se litigant, and courts hold pro se parties to the same procedural standards as attorneys. The absence of an attorney does not automatically entitle a litigant to a continuance. Courts consider the diligence of the party when deciding whether to grant additional time. Given the complexity of divorce proceedings, hiring a new divorce lawyer after your prior attorney withdraws is usually the best course. Lawyers may be hesitant to join a case that is already underway when hearings or trials are scheduled, so acting promptly during the 21-day window can help you secure representation. Remember that the attorney-client relationship terminates once your judgment of dissolution is entered. Future motions to enforce or modify the divorce decree will require re-engagement. If your divorce lawyer has withdrawn, or if you need guidance after the court has granted the motion, seek a law firm that can review your case and advise you about your options. The Law Office of Russell D. Knight in Chicago offers representation and guidance for Illinois family law matters. If your divorce lawyer has filed a motion to withdraw and you need help navigating the next steps, contact the law firm at 1165 North Clark Street, number 700, Chicago, Illinois, 60610. You can call 773-334-6311 to arrange a consultation. This attorney and his team understand the nuances of Illinois divorce law and can help you move forward confidently.